Somebody down here just said they did it. And the other question was the
You guys keep them pretty busy.
copyright photo stuff.
It's amazing.
I like reading your stuff, yeah.
You
I sent
know, I
that.
enjoy the stuff where we can just help and point them in the right direction. But some of this corruption going on in Florida, that woman up in Dalton, it's just a matter of time before she's indicted. She stood at the gas station and just swiping the cards for anybody to come through. Vote for me on the township credit cards on video.
Wow.
Yeah, like 3 or 4 days straight.
I don't watch news, so I don't have any idea.
I gotta watch the news either, but I haven't seen that one.
I don't even have it
That's
available.
interesting.
We just live stream TV and that's it.
Yeah, it's amazing some of the stuff. It's one thing to know or make stupid mistakes, but some of them are just, that road commissioner that got indicted, 21 count, or 23 counts, buying chickens and water heaters and 30 packs of beer, all on the road district credit cards.
Just a screenshot of
And didn't think a thing of it.
Nobody was watching the card come in?
The attorney for the township recommended that if he pays it back, just let it go.
Sure.
And they put that in the minutes.
No, that's
So
okay.
that's what he did, he paid it back. The state's attorney fortunately said, no, passed it to the AG, AG indicted him last month.
What town was that at?
It was in DeWitt County, I can't remember the name of the township, Donald website, he did the first story on it. I can't remember the name of it off the top of my
We'll
head.
run you guys ragged. We'll have you guys running ragged all over the state.
The townships are the worst.
How do they think they can use a credit card and not get caught?
Well, in that one, it was all, for the most part, family members that sit on the board, approving the bills. And they never saw the credit card statements, they just saw a warrant for the payment
Right,
on a sheet of paper, here, pay this credit card bill,
right.
and they didn't have a breakdown of what was being bought.
That's wild.
I'll be in meetings most of the afternoon.
The 120s is Metro.
And like Bell and stuff like that, we're all, but we don't know if they're all.
Okay,
John,
that
what was that
we might have missed them.
Buying the chicken.
Oh, Township Road Commissioner. It was in DeWitt County.
Don't you think that Illinois should amalgamate some of these townships? I mean, we've got, what is it, in this county, how many townships do we have in this?
Most of them have like 15 to 18.
Right, yeah, I mean,
Yeah.
it seems redundant to me to have that many supervisors and that many, maybe they needed that when communication wasn't as good and the technology we have now, but now with everything, it seems like they could save a lot of money by just combining some townships.
I would say, at least in Edgar, there's probably,
There's 15 townships in Edgar
and
County.
there's probably only 2 or 3 that give out any type of general assistance. The rest are just there to do the
I
road.
tried to abolish ours when I was supervisor for 8 years. Well, I was on it for 10, 2 as a trustee and then 8 as a supervisor. The only thing we ever pay is the road commissioner bills
Right.
and then our electric bill and phone bill.
So what does it take to abolish it? I mean, it's like a referendum in the township, couldn't get them to vote for it. That's the problem.
I couldn't get the board has to adopt a resolution to put it on. The board wouldn't do it.
To eliminate themselves. That's my,
That's always the issue. That's always the issue.
And that's where they would have written the law to where the voters could petition.
Right.
To do it, it would have been better, but they didn't. They left it up to the township boards, have to adopt a resolution to let it go to the ballot.
Because you've got townships that major cities are in that are taking care of the roads and doing all the stuff, and then you've got this township that you're paying, I mean, what are they, maybe a few country roads on the edge of town or something? I mean, it's
Well,
crazy.
you get up north, that lady that was running the credit card for gas, she's making what?
$240,000 a year just on her salary.
What
As
was
a
she,
supervisor.
what was she was a
That
township
doesn't
supervisor?
count her like $6,000 or $7,000 a month expense allowance. And if she goes anywhere, any day to do anything within Cook County, she gets another $200 and some that day. But if she goes up to a separate county to work as a supervisor, she gets like $400 a day.
So every day she drives out of the county to conduct township
And
business.
she's a
And then
township
she's-
supervisor?
Then she's still in the blind with the township credit card, paying for all the stuff that the village of Dalton won't approve payment for, that she wants to buy the village of Dalton when she's a mayor of the village.
That is wild.
She'll go to jail.
Just
It's only a matter of time. I mean,
But in the meantime, the money that is being taken from the taxpayers is unbelievable.
That's sad. Even if you just take out the corruption piece, the amount of money you're making as a township supervisor,
That's criminal.
that's a ton of money.
she,
It's just
I think we got more townships than any state in the country, don't we?
Yes, sir.
I mean, that's
Probably
been
by
a thing
now.
for a long time, if you did away with a lot of those.
she started her own nonprofit, cut a township check of 10 grand, did a
Yes.
10-day march to Springfield, spent like 27,000 on that, all on the township credit card.
She went to Selma, Alabama. We're waiting on those credit card statements too.
To walk
She went
across
down
the
there.
bridge over the weekend. And took an entourage with her. She has adult
Is this
police
like a
following her
wealthy
everywhere.
county or something, or township?
They would have to be, that's a lot of money.
Thornton Township is the largest township in the state, but it's on the south side of Chicago. It's in Cook County, and it is,
Well, that's probably why, right there.
there's a lot of boarded up property that's still in Cook County. And the population is pretty dense. There is a lot of money, and that's the problem. There's been no accountability. I'm the supervisor. I write the checks.
I think hired people to go around and mow everybody's yards in the summer.
She bought 2 fully equipped police cars, unmarked squad cars, and put township plates on them so she could drive one, and her,
Municipal police plates.
I think it was her security guard was driving the second one.
Just security
Security
guard as a
guard?
township supervisor?
She's got a group of them. No, that says the village mayor, but they also follow her around everything for the township.
Yeah,
Oh, she's the mayor too.
yeah, she's the mayor of Dalton, and she's the supervisor of Thornton Township.
Wow.
I called up the Secretary of State and told them about those 2 township police cars. They were up there the next day taking plates on.
What,
So she turned around and put Dalton, city of Dalton plates on.
all at the same time? Okay,
The way it sounds.
okay,
She bought it
that's
with road
fine. I
district
mean,
funds.
they can
That's wild.
do what they want.
You know, good work, gentlemen. I mean, you know, you'd think somebody up there local would notice that.
Well, they did. They reached out to us, but they're up there, they're afraid to go to cops.
Really?
They won't, they'll tell us, but they'll tell the police. I mean, we've been to meetings and we're watching police do things that should be in federal court. Kicking people out of public meetings.
Before it even starts because she doesn't like it.
The mayor says, I want her out of this meeting.
These are the ones that are.
And they asked for it out of
These are
meeting.
the ones that he said he wasn't even gonna talk about. Okay, so I don't know,
Boy.
but this one's here.
God, I wish I could do
Yes.
that.
She'll end up-
It is coming back, but there's
She'll
no
end up
reason
in
for it
jail.
either because he
Mark
said
my
he's not
words.
talking about it, so.
It might take another year, but
Same
she
reason
will
that
end up,
it shouldn't be in here.
How long has she been doing that?
So these are the ones that have checked in.
less than a year.
Okay,
Oh,
so I don't
yeah.
know if you wanna mark
She
them
got
on
a
the
point
other
sheet.
sheets here. I mean, they're all
Gosh,
up here.
she was a trustee for
Okay,
the
I
village,
know, I
got
saw
elected
graphics
mayor,
and
and then the township supervisor croaked.
dust.
And then she offered, allegedly offered one of the trustees a job, $100,000 a year. Village.
If she voted.
And she paid for another trustee's dead husband's funeral, and then went there and roughshod over that meeting, and got appointed as township supervisor.
It's like the mafia.
Oh, man, big time. But it's right in your face.
Those are the only ones that.
There's no
are
intent to
funded.
hide it
Okay.
at all.
Well, that's not-
Hell, one of the village
And then
employees tried to
Thomas.
shoot me for taking a picture of the village
Yeah,
trustee board.
that were here this morning.
I kinda egged it on all of it.
A video,
What, you taking pictures of that truck? Because I felt like I got a problem with it, and then that went downhill from there.
It's rough. Sometimes I'm really thankful to be from, you know, southern, down here it's a lot slower pace, a lot smaller.
yes.
It's, you know, the city's cool. I mean, if you get up there, you get a lot of cool stuff. But
It still happens, you still get crazy, so I mean, Harrisburg Township.
where's that at?
It's down south.
Harrisburg.
Marion,
Saline County?
Salem County. So they, $100,000 annually for general assistance. They write 2 $100 checks a month. The rest goes in wages
So they're helping two people,
for general assistance.
but all the rest of it is their,
$96,000 in wages to hand out two $100
Now
checks.
legally, does that, I'm assuming that assistance money has to be used for assistance, right?
Yep.
Like, yeah.
Or wages for the
For the
assistance
assistant,
appropriate.
yeah, right.
So whatever he's doing is perfectly legal. I mean, nothing against the law of paying somebody $96,000 to write $4,000 worth of check.
Oh, wow.
I mean, I wish I could get that job.
Just sleep, go to sleep.
Oh, it's 1:30. So, so Mr.
Cashier,
Gore,
I'm just trying to
who,
come in, yeah.
well, I think they just said they're all
That's
coming
why I
back.
said that.
So, that's,
Yeah, it's wild, guys.
It gets worse.
oh yeah, we could go on for hours. We could do it.
See, I'm glad I don't watch the news.
We
Stuff
could
like
do
that.
a your government comedy hour and people wouldn't believe it. They would just insist.
Surely other
it's all
states
fair.
have this problem, right? This isn't,
What's that?
this isn't an Illinois problem. Like, these other states have these issues, I'm sure.
Oh man, we're dealing with one in California right now. Blow your mind.
Good afternoon.
Hello. Which one would you like to start with?
Whichever one you would like to, sir.
All right, I just picked one off the top.
I just need to know who it is so I can pull the file.
All right, it looks like it is Patrick and Maria Dust.
Ladies like to see?
Dust. That is 05239. Does that help you?
No.
No?
Sorry. Can you see over in here? 5239.
All right, 36 Sugar Creek? Is that
Yes,
correct? All right. Looks like we made no change. This is your opportunity to change our mind.
Well, I think you did make a change, just not the change that my client asked for. Looks like the assessor, it was at 144 and you dropped it to 129.
That was we removed the multiplier because once can't be reassessed and have a multiplier. So, but I mean, past that, we didn't make a change. I apologize.
All right. A lot of these are going to be a lot of overlapping arguments, and so I'll just be more detailed in the first than I will some of the others as we go on. But, I mean, generally speaking, I'm going to say that this board can fix these issues, or we'll go to PTAB, and again, I never say this as a lawyer, but I'll say it here, there's a 100% chance that these are all going to get redone at PTAB. It is no secret. I've done a lot of property tax appeals in my career across this state, and to be perfectly honest with you, I have never seen anything in more disarray than Coles County. As you guys are aware, Coles County was broken up into reassessment districts in 2015. Had to do with the commercial appeals. There's actually a lawsuit pending on that. But nonetheless, it was broken into assessment districts, and you have 4 of them. And I'm assuming that this board is aware, because I'm not sure, with all due respect, that the assessor is that when you get an assessment district in that year, you have to reassess every property in that assessment district. That's why you break properties into assessment districts, is so you don't have to reassess every 4 years the whole county. You make it in a more manageable fashion, which is what the county board did. So for Lafayette Township, 2022 was the year to reassess all of the property in that assessment district. Lafayette is one of 5 townships in Assessment District 3. Your assessor has admitted that they don't do that. They've admitted that they don't have the resources, which is, again, it's probably true. It's not uncommon statewide. They don't have the resources to reassess every property. And even in the assessment district that is up for that year, which again was included Lafayette Township. I've never had, and I appreciate the honesty of the assessor, right? It's usually, they're not so forthcoming, but has acknowledged that we don't reassess every property. The math in the tax appeal that we've broken down, that made a science project out of you, actually shows and evidences to you that in Lafayette Township, 8 out of 10 properties merely got the multiplier that your township assessor created based upon a 3-year median level of assessment. The math is in here. We've attached it as an exhibit. And so that 11% multiplier was used in Lafayette Township during, again, this is the reassessment year. That in and of itself is illegal. You can't use a multiplier in a district that's up for reassessment. You have to reassess the properties. You have to inspect each one of them. You have to determine its fair market value. And again, you have to do it uniformly. We all understand that. They've acknowledged they didn't do that, gentlemen. They have admitted it. And when you look at the math, it shows that 83% of all properties in the township just got the multiplier. For some reason, of which I am not sure, the assessor's office, and there's an email in here between the assessor and the gentleman's name who escapes me, I apologize, the township assessor, that there was a decision made to reassess certain subdivisions. Not all of them, because there's 28 subdivisions within Lafayette Township. In these 6 townships that we've broken out for you, there was a decision made, we're going to go reassess within that subdivision. That is illegal. You cannot do that. You have to assess properties the same way. Now, if your assessor had chosen to say, I'm going to use a multiplier for everybody in Lafayette Township during the reassessment year, it's unlawful too, but at least it's not lacking in uniformity. Applied the same theory to everyone. Okay, that doesn't fix inequities, because as you've seen in the documents we've attached, based upon your 3-year median level of assessment histories, there's properties assessed way under-assessed, there's properties way over-assessed. And that uniformity problem is supposed to be fixed when you do a reassessment every 4 years. It is no secret that it's been at least 2 decades since your county's done that. Everybody knows that. Okay? And I'm not here to openly criticize the fact that it hasn't been done, because to be honest with you, it's not uncommon that it hasn't been done. But nonetheless, when a decision is made to say we're going to go grab a hold of a few towns or a few subdivisions and reassess them and let the rest of it go, again, it's unconstitutional, because what you're doing is you're saying, for example, my particular client here, who started off last year with a $98,548 assessment, went initially up to $144. It was a 46% increase. Why 83% of the properties in the county only got the 11%. You can't do that, because what it ends up doing is it makes them pay more of the tax burden than everybody else that didn't get looked at. The law is crystal clear. Again, it's not 99%, it's 100% crystal clear that can't happen. Now, interestingly enough, what I found, and I really, maybe, I don't know if this Board of Review did it, or if the assessor did it, but of the 42 parcels of property in Lafayette Township that I filed appeals on behalf of my clients, 22 of them, this Board of Review sent a notice and reduced them down to just the multiplier. This property here, my client that we're talking about right now, their neighbor right next to them got reduced to the multiplier. They live right next to each other. But yet, for some reason, the Dust family doesn't get that same relief. So not only do we have assessment practices in this county that violate statute and constitutional principles, the Board of Review, when it's doing its review and analysis, seemingly made a decision based upon, because my client's legal arguments, gentlemen, are pretty much identical. Some neighbors got dropped down to just the multiplier, and again, 20 of them didn't. I tried to rationalize that. I could not come up with a reason on why this Board of Review would say,
She
okay,
did not give you our math and our comps and all that.
I didn't see
They
anything.
did not provide you that.
No.
They should have provided you that.
And keeping in mind, I think you should, Mr. Frederick, is that right? Okay, Mr. Frederick. The math and the comps and the things that you're talking about, sir, I'm suggesting to you, none of that analysis matters unless you apply that same analysis assessment district-wide.
Right.
Okay? I mean, I'm assuming you're aware.
Well, the Board of Review's purpose is to look at the value of the properties in front of us. I can't do an assessment. This is an argument with our office, it sounds like. And
No, I disagree with you, sir. Your job as a Board of Review is to, my client is complaining to you that they were not treated uniformly based upon the rest of the people in the district. And if this board is aware and has knowledge that my client, the Dust family, was assessed in a method that was not applied to the rest of the assessment district, then they are entitled as a matter of law to be treated the same. That is this board's purview. And again, as seemingly that this board did that with 22 of the 42 properties in Lafayette Township. Because again, the arguments that we made to you, and I'll pick one of them. Because this property is on 36 Sugar Creek. I'm going to find another one on Sugar Creek. You know, for example, here's 47 Sugar Creek. You dropped it to the exact same, to 11% multiplier. Here's 48 Sugar Creek. You dropped it to the multiplier. 55 Sugar Creek. These are all the same subdivision. They were dropped to the same multiplier. So the arguments we made on those cases, sir, is that irrespective of what fair market value analysis might determine, we have to be treated like you treated all these other folks. And again, when you go back to what we argued in the grand scheme of things, you have 28 subdivisions in Lafayette Township. All of them but these few, there was no review by your assessor. They didn't go and say, well, is this subdivision under-assessed? Do they need to be, or maybe they're over-assessed and need to be reduced? The law is clear, and I humbly suggest to you, your state's attorney knows, the law is clear that the methodology, you as a Board of Review have to make sure that the methodology applied to my clients is consistent with everybody else. And I can, but based upon your comments, Mr. Frederick, I think you probably realize it's not.
it's consistent with Marksboro. We did Marksboro as a pod. That's why I asked if you'd gotten our work.
No, and I haven't seen your work, but even without your work, in a reassessment year, it cannot be that you say, well, Marksboro and these other few subdivisions, we're gonna do them uniformly. But everybody else, we're not even going to look at. We're not even going to pay attention to them. They just get a multiplier. That in and of itself is enough for the Property Tax Appeals Board to say, I'm wiping it all out, and it's going to be the multiplier. That's because, again, you can't pick and choose. So, you know, if this board wants to say we're going to pick and choose, and you're going to make a record of how you picked and choose, then we'll just have to go and take it to the next level. But, again, there's properties within Sugar Creek, which is where, again, we're talking about the Dust family. There's properties in Sugar Creek that you change just back to the multiplier. So that, to me, would cut against when we looked at a subdivision and did market value on a whole subdivision, which is unlawful. But even within this subdivision, this property, it seems to be that you believe that the Dust family's fair market value was not needing to be changed. But all of these other properties in that subdivision that got dropped down to 11%, again, we didn't even ask you to make any adjustments based upon fair market value. We asked you to make adjustments based upon lack of uniformity. And you seemingly agreed with that argument because you made the 11% change. So, you know, I've spent a lot of time on this one because the arguments are going to be the same in a lot of them. But again, if this board wants to issue a decision saying that we're going to apply a market value approach to the Dust family, even though it acknowledges that market value wasn't used in Lafayette or all of Assessment District 3 overwhelmingly 80% of the time, then again, we'll just have to take it up on appeal, and again, my clients will win. But I don't know why we would put these people through all of this. Why are we putting through 22 people of my clients, who's all I'm here to represent? Why are we going to put them through a PTAB review and appeal, and then they'll get their money back? For what? Why are we doing that? Treat them the same way that you've treated half of my clients and 80% of the rest of the people in Lafayette Township. And then I think this, hopefully somewhere in this county, the county board is going to start looking at how do we fix this. Because what your county needs is a full-blown, kind of like you did your commercial properties in 15. You need a full-blown residential reassessment. And then on top of that, you're going to have the infrastructure in place to maintain that. That's imperative. But in the meantime, until you're able to do that, uniformity in treating your taxpayers the same, which again, if 11% was the multiplier that the gentleman calculated for Lafayette, use it for everybody. Some people, that's still going to mean they're underassessed. So some people are probably still overassessed. But if you're going to fix that, you have to fix the whole thing and not say, well, we'll look at Marksboro. Because as I understand it, and we'll get to Charleston Township, even in non-reassessment years for a particular district, they're still going in there making fair market value changes in districts that aren't even up for reassessment. And the impact that has, like it's having the impact on the Dust family, irrespective of whether or not their property is worth $390,000, set that aside, is that their assessment was altered and increased in a different methodology than overwhelmingly everybody else. That's the only argument that I really have to make to say I don't care what their fair market value is that the theory applied to them, they were pulled out of a pile for some reason. Maybe people called your assessor's office and said Marksboro's underassessed, or not. Because the ones that you have out there, it looks like in the golf club area, I looked at some, and it's in here, you have it. I looked at some of the sales in that area. Those properties seem to be underassessed too. Why didn't they make the stack of, well, reassess Marksboro and that one? For some reason, they were left out. Whatever that discretionary decision was, I mean, I've had people say, well, they know people. I don't care. It's none of my business. All I know is you can't leave them out. You had to do the whole thing. And your township assessor, again, readily acknowledged to most of these people in here, we don't have time to do that. Okay, I mean, it is what it is. So we proposed for this property owner last year's plus 11%, which brought him at $109,388, right? And if and when the time comes that this county wants to reassess, even if it doesn't do the whole county at once, let's say that next year in 2023, I don't remember which assessment district is next, I think it's 4. If the county wants to hire somebody and say, okay, we're not going to take on the whole county at one time, but we've got assessment districts, so 2023, all of the District 4, which I think is next, we're doing a whole township or whatever that district is. That's fine. But this year, with 2022, within what included Lafayette, just picking and choosing the few properties disenfranchises these property taxpayers. And again, it's reversible to make them pay more than the 11%, and I'm asking you to treat them the same as everybody else. Thank you.
I have a question. Why weren't new property cards sent out with these reassessment notices? I think the Dust might only have one copy of their property card,
We don't.
and all of a sudden they get this
The
piece
Board
of
of
paper.
Review's only job, as I understand it, is to value properties to equitably and to fair market value. Past that, we don't do the cards. We don't do. I can't answer that.
I understand, but what I'm saying is that they don't have any idea what was changed on their property.
And may I say this
None
first?
whatsoever.
And keeping in mind, when we appealed to you on the Dust family, the appeal was based upon lack of uniformity based on constitutional principles. We did not appeal based upon fair market value. saying that there was a square footage issue, or my neighbor's property is worth this or that. You know, you guys see those a lot. So when I got an adjustment for this client's property, well, you didn't actually do an adjustment on this one, right? So, but there were a few of them that we'll get to where even though I made just a uniformity argument, there was a reduction, and I was like, I didn't know why, because we didn't ask for that. But on this one, you're right, you didn't make any changes on this one, so we'll get to one of the next ones, yeah. But again, I understand, I believe, you know, what's going on in the county, and I believe everybody understands what has to be fixed. And it's, a lot of it has to do with finance, right? Your assessor does not have the people to do what would have to be done. I know that, right? I understand that, and I'm sympathetic to it. All I'm saying is that for my clients, that until such time as the county has the ability to address that, you have to treat my clients the same way you treat everybody else, right? You have to treat them the same way, and what you cannot do is to say, well, we have this resource issue, and so I'm going to, within 2022, I'll do a few subdivisions in Lafayette. And then maybe next year, even though it's not a reassessment year, I'll do a few more in Lafayette. The law doesn't allow that. Now, it may be inconvenient for an assessor who's underfunded and doesn't have what it, you know, the resources. But my clients, and again, we're talking about the Dust family now, their assessment went up, you know, 30,000 EAV, so times $7, I'm just picking $7 a hundred rate. $2,000 a year? Because of what? Because maybe if we would have assessed the county or the township correctly, and everybody would have gotten a fair market value analysis, their tax bill wouldn't necessarily, it might not even go up, right? It might even stay the same. I give this example, when you got 2 properties in your whole assessment district. You got 2 properties. Me and my neighbor are both worth $300,000. And we're both assessed at $100,000. And then during the assessment cycle, for whatever reason, our properties went up, but only one of them goes up in assessment. So that person's going to pay more even though their properties are the same. That's what's going on here with thousands of parcels. You know, my client's property may be worth $390,000. I don't know. But guess what? All of the other properties in Assessment District 3 might have went up in value too. And so again, my recommendation for my client here and for the others, treat them the same, and then hopefully this county can figure out how to fix what is a much, much, much bigger issue. That's all I'm asking.
I'd like to speak if I can for a moment too. I'm on this list, although probably not in the yellow. I'm Sarah Hocking, and my house was way over assessed. The assessment that was done had so many errors in it that almost $200,000 had to be taken back off my property because it was a second floor I didn't have, finished basement I didn't have, extra bathroom. I mean, at least as far as plumbing, utilities, and an additional basement under my driveway that I didn't have. So these were glaring errors that were made on my property. And they were made across my neighbor's properties also. So for that to have been done, and then for me as the taxpayer to hear that, well, the assessor's office doesn't have the resources to do it right, that's not okay. That's not an excuse. This assessor has not asked for the budget to be able to do it right. She's not requested additional money, at least according to the county board hearings that we've had and the rules hearings that we've had to explain why she couldn't do this in a decent manner. So I don't even think it's okay to just say, we get that she doesn't have the money to do it right, so we'll just do it wrong. That is not okay. Thank you.
Any questions from this property tax appeal for the Dust family? Anybody? No? Yes, sir.
We did, you're right, we did not look at. We took all your clients
Yes, sir.
and all of the others that made an appeal from our store that weren't your customers, and we took them all. And several of them had done appraisals. And we took those appraisals and figured it averaged out and figured out square footage, and then we applied it to everyone that was in Martinsboro. The Dust family, it came out the same. I mean, there was no change. On many of the others, there was lots of change. And that's what we did. And that's why we did it.
May I speak to that, sir?
Certainly.
Two things. One, whatever that analysis that you were doing, which that analysis would be something similar that you would do, but it wouldn't result in reducing their assessments to exactly the multiplier. Whatever the values of those properties are. Because again, we didn't ask for you to do that analysis on any of those properties. Second thing I would say to you, sir, is that theory that you're talking about did not get used on overwhelmingly all subdivisions within Lafayette Township.
No, it didn't.
You just, and I appreciate your honesty, so when you just said no,
They didn't appeal.
no.
All we dealt with was people who appealed.
What I'm saying, and I understand what you're viewing, but what I'm saying to you is that your assessor did not do, and you have to pay attention to that because you have to make sure as a board of review that these property taxpayers that have appealed are treated within constitutional guidelines. It's your job. Your job is not just to look and say, well, what is the fair market value analysis of their property? So when you're talking about you took these appraisals and you're looking at values, let me give you the one. Augusta Lake subdivision. It's a very valuable place, right? If you look at the properties in there, every one of them got the multiplier. Every one of them. If you look at the sales history of a few sales in Augusta, those properties seem to be selling for more than what they're assessed at. Under assessment is common across the state. A lot of properties are under assessed. Okay? Moore Pine Acres has over 100 properties in it. All but one or two received 111%. Okay? So what I'm saying is that fair market value you're talking about for my client and the others that appealed is not the window that you have to look through. You've got a bigger window to look through to say, well, wait a second. So we now understand that, again, I've got, you guys probably didn't read all this, but the record's made for PTAN. It's not necessarily made for you. 83%, 8 out of 10 of the properties in Lafayette Township just got the 11%. You can't do that, right? Doesn't matter what market value says. You can't say, well, you can't go to my client, well, is your property worth $390,000? You can't do that. Because again, we can go into all these other towns or these subdivisions, and you could ask your assessor, you don't have to ask her now, did you look at any of these properties? The answer will be no, we know that. That's something that you gentlemen have to figure out and say, you know what, we cannot allow our assessment practices in this county to start taking a subdivision here or subdivision there, making an analysis based on market value when you're not doing it with the rest of Assessment District 3. You have to do it with Assessment District 3. And if you're not prepared to do that, you can't just grab a handful of them and do that and leave the rest of them out. Because again, I have argued that case in front of PTAB and I've never lost it. I can tell you, I've never lost it. Because they're going to make sure that whatever your practices are here, that you treat them all the same. Because the Dust family can't be made to pay $2,000 more a year without there have at least been an analysis and a decision made that that shouldn't have been absorbed by some of the other people within the township. I think you, Mr. Frey, I think you get what I'm saying. And so, for those reasons, the market value of what my client's property is worth doesn't really matter. Because you've acknowledged that the market value of 8 out of 10 properties, your assessor didn't even look at. And I'm not criticizing, I'm just pointing out the reality. I'm not doing that to make anybody look bad. I'm just saying that this Board of Review needs to acknowledge and say, if that's where our assessment is at in Coles County, because we don't have the money, which I guarantee you don't have the money, and whether she's asked or not, it's not for my, those are for the citizens of Coles County, it's not for me. But in the meantime, until that money is acquired, until, again, hopefully next year when Assessment District 4 comes up, maybe this county will be in a position to say, okay, we've got you the resources, we've got whatever, and we're going to reassess this whole 6,000, 7,000, 8,000 parcels. We're going to do it right. Then when you do that, then it becomes important of, okay, did we use the same rate per square foot? Did we have the fixtures at the right amount each? Are the fixtures in this subdivision the same value as here? Because different markets have different values. That becomes really important for your gentleman's job once you've established that at least the practices are uniform. So, anything else on the Dust family or in general? Mr. Frederick, this is 2 Kelsey Drive. It is Daryl and Shirley Stephan. How do I dare say it right? Always mess it up, Daryl. Where you at, Daryl? Help. Stepanovic.
Matt, give me a question on the process. Do you guys make a determination on each one here in this meeting, or do you meet?
We certainly can. We usually do before the taxpayer leaves. We make a decision.
But we're not going, I mean, obviously we don't, we're not attorneys and. we're
Right,
not
that's
really-
the problem.
We can't, we
don't-
can't rule on constitutionality and all of that stuff.
I just didn't know when you would make a ruling on each one of these, whether it's.
Well, whether you're not being asked to rule on constitutionality, Mr. Lawrence, but I think you are going to be asked as a board of review to determine, are the assessment practices being applied to these property taxpayers? The method of which they're being assessed, right here, was it used consistently across the assessment district? That's the question that you'll have to answer. I think you know the answer. And I think, the answer being no, it wasn't, I think it speaks for itself. But with this one, again, this one is, we appealed based on 2 things. We based it on, we did attach an appraisal, but ultimately, again, that market value analysis is secondary to the constitutional arguments for this meeting. I'm not going to rehash that all over again with them, okay? So they had an appraisal done. The appraisal came in at 235. They were at 63 last year. Assessor took them up to 91. You brought them down to 73.8.
Which was their appraisal.
And then the 70,113 is what we recommended. So keeping in mind, making the argument as a backup on fair market value, this is a good opportunity to point out. 73,792 may be based on fair market value. But what I'm saying to you is that given that 83% of your properties in the county, fair market value was not the standard. It was not the standard for those properties. These folks have to be treated the same way, which that's where the 70,113 comes from. It's going, you gave everybody else 11%, they get 11%. And when the time comes that you have to reassess, and you reassess everybody, then the number that you've got in there may make sense. But my clients have a right under the law to say, I don't care what my market value is. You treat me the same. And there's case law all over the place that says if my neighbor is underassessed, I have the right to be underassessed. Yeah, you get familiar with that. And so that's where this case is at. So I thought that's probably why you made that adjustment. But again, ultimately, we will, instead of making the arguments all over again, all of the arguments we made on why the 11% should apply in the prior to the Dust case, I would apply to this case, okay? Make it a lot quicker.
And additionally, 2 homes on our street were reduced to 11% as well.
Yeah, I have this spreadsheet. I think I sent it to the assessor. Did I send? Okay, and I want to incorporate that in to, because I think it's important for your review, is, my property was on Kelsey Drive, and there were others, for example, Todd and Shauna Krasinski, I hope I said that right. We made the argument on them based upon the 11%. They got the 11%. There's 6 Kelsey Drive, the Nichols family, got the 11%. And again, we made constitutional arguments in those cases, which I thought, again, ask you gentlemen to consider. When we made arguments based solely on Constitution, and you gave them that relief, what was the reason you gave them the relief if not for the arguments that we made? Because those were the arguments we made. We didn't say my neighbor's worth less, or they did an appraisal, and they did it. We just said, treat us the same, and you dropped it down, so. But yeah, there were others in our appeals on that same street that got the 11%.
If I could, I'd like to add one other thing too. Mr. Barnes and Ms. Shores did come to a meeting that we had at the Lafayette Township with just a bunch of our homeowners and explaining why, you know, we were so upset with all of these numbers all over the place, and asked if our subdivisions could just be given the same 11% that the rest of District 3 got. That if they didn't have time to look at everybody else, then we should be treated the same and get the same. And we asked for that back in November, before a bunch of us had to spend $500 to get a new appraisal. Because my house was appraised in 2019, but we were told that appraisal is too old to use. So I forked out $500 before Christmas. I forked out $1,000 for my attorney to represent me, as did all my neighbors. So I'm out $1,500 because of mistakes that were made. And we're all still here because of it. Thank you.
Next one I have is 37 Sugar Creek Lane. Be the Collins family. Ready, sir? Yep. Collins family is in Sugar Creek. They started at 75,000. Assessor took them to 117. We asked for 83,698, and this board proposed tentatively 85,417, which was a 13.28%. And I'd point out in our appeal, we appealed for lack of uniformity based upon the assessment practices to be treated last year plus the 11%, and for reasons that we're not aware, this board made an adjustment within 2.28% of what we had asked for. So we don't know why. We're not certain where that come from.
I think Dan told you where that came from.
That's what we did.
So do I understand correctly that this board made a market value analysis on all my property tax owners, even if they didn't ask for a market property analysis?
Yes.
Okay. So would you be
We were
suggesting?
trying to be fair, yes,
Fair and equitable to that neighborhood,
for that neighborhood.
which on my understanding is allowable.
Well,
as
it's
a
not, but
neighborhood.
that's okay.
Well, like I said, I'm not.
That's what we were trying to do.
Yeah.
Neighborhoods can be used to value based upon that area. We explained this, and you don't have to believe me, that's fine. So if you're going to do an analysis of market value, and you want to be uniform, you can look at a neighborhood. That's not inappropriate. But what I'm saying to you is you can't go within a neighborhood and apply market analysis when you don't apply market analysis district-wide. Okay? You can look at a neighborhood and say, we're going to look and we're going to treat these fixtures this way in this neighborhood, or maybe the square footage per, is similar in this neighborhood. You can use a neighborhood to create general drivers. What you cannot do is say, I'm going to go into this neighborhood and apply a market value, but not apply that market value across the rest of the assessment district. You can't use a neighborhood for one methodology and then use a different methodology every place else. That's not allowed. But what is allowed is to, look at neighborhoods when you're evaluating market. You can do that because this neighborhood is probably different than the Augusta neighborhood, right? They're not the same, I'm guessing, based upon what I can generally feel. So you can look at neighborhoods differently that way. But again, to be able to say, well, we'll look at this neighborhood and do a market value analysis, but 20-something other neighborhoods, just get a multiplier. I would ask you to look into that, but you'll find that that's not allowed. So okay, so based on this one, you did a market value analysis and came up with 85,417, and we asked for 83,698 based on the 11%. So I believe you gentlemen know what our argument is on this one, is that your market value analysis treats my clients differently than, again, almost everybody else within the assessment district. And I'll point this out too. So if I go through and I look at the 22 properties that you gave, well, 19 of my 22, about 11%. So a couple of them were even less. You would suggest to me that your market value analysis on these properties that you dropped to the 11% multiplier, that your calculations of market value came out exactly to the 11%?
Yes. Either that, we may have, since you were asking for less than what our market value, we took it to what you were asking for, plus the 11.
Okay, how are we going to get into that? Let's go to the next one.
Hey, one question, this is Daryl at 2 Kelsey, so.
Yeah,
You're
Daryl.
not gonna make an adjustment on ours, given, you make no comment, so that's it?
I don't think they've made a decision yet, so I'm not sure how they're going to, I'm not sure what they want to do with that.
I'm just wondering, going through, no answer.
21 Sugar Creek Lane. Planky. All right, and it looks like the Planky family started at 78,891. Assessor took them to 121,706. We asked for 87,569, which is the 11%, and then you ended at 98,554. And we also attached an appraisal to theirs, again, as a backup argument. You guys are clear on that, right? Then their assessment, or their appraisal came in at appraisal came in at 260. So appraisal came at 260. We were asking for about 260. 2.5 or something like that, 87,569 times 3, and yours has them at a little under 300,000. So, you know, what we had asked for, the 11% increase that we had asked for is within a couple $1,000s of what their appraisal was. So, you know, again, the appraisal being the backup argument, it just happens to be that the appraised value, according to their appraiser, is pretty close to what the 11% increase from the prior year would have been coming out to. It's not within a couple $1,000. So I'm assuming your 98,554 was on a fair market value analysis that you had done. And so for the constitutional reasons we've argued, which is bolstered by a pretty close assessment, we would ask that the 87,569 be awarded on the Planky family. Ready, Mr. Frederick? Let me get a second.
I think we want to make a decision on this one.
Okay.
It was not on the, we had no appraisal on the docket.
Oh, understood.
Flat out.
It was attached.
Like it, yeah.
Yeah,
It was in
okay.
there,
I
but
said, I hope I didn't miss it, but I
you
thought it
gotta
was
realize we
attached.
go through hundreds and hundreds of
Oh, no,
names
I
on
get
the
it.
docket.
Those are
I'm not
human,
gonna go
those
fit-
human
I'm not
errors
gonna
happen
go fit
every
every
day.
Yeah.
I
so-
get that.
appraisal's less than what you're asking for,
No, it's 11.
though.
The appraisal's a little under the 11%, right?
Right.
Yeah,
So
so,
the
I mean,
appraisal would be,
Yeah.
we asked for both of them in the alternatives,
I would give you the appraisal.
appraisal. Sure.
yeah, that's an easy one.
That's neat.
All right, so that one, put that one off to the side. Okay, sir, this one is 54 Springchester, Mattoon, McQueen. Oh, I think this might have been the one that we've already, I might have been in the wrong box. I think that one's good, right, sir?
That was in your list.
Yeah, that one made the wrong stack.
At least I had it marked up.
Yeah, Mr. Herman, that one's good. Sorry about that.
So we don't need the claims?
No, ma'am. My 19-year-old son was helping me organize these. Okay, let's see. Grafton. This address is 23 Sugar Creek. Yeah. Bruce Grafton.
Yep.
Ready, sir?
Hmm?
I mean, this one, again, it looks like the same, it's in Sugar Creek. We proposed the 11%, you proposed, we did based upon your analysis, it looks like you reduced it to some fair market value number. I'll take the opportunity now to point out just a couple of the, I'm gonna go to page 6 of my appeal, when it talks about using equalization, right, a ratio. And it's been established for decades. A ratio must be applied uniformly to the entire county, township, or district, and not to just some of the properties. And that case law is crystal clear. You know, it requires equalization of the tax burden, prohibits taxing officials from valuing one kind of property within a taxing district at a certain proportion of its value, while valuing the same kind of property in the same district at a lesser or greater proportion of its value, right? That case law has been around. Abandonment of the mass appraisal method of assessment in individual cases while applying it to the majority of properties results in a constitutional violation. That's the Walsh case. That was actually, the Walsh case came out of Tazewell County to where the court ordered a complete 100% reassessment based upon what we're talking about right here today. The fact patterns were almost identical, except in Walsh, they hadn't broken their properties into assessment districts. It was a county thing. They had the same issue. And so what we've got here, we've got mass appraisal on 83% of the properties in Lafayette Township. It was mass appraisal using the 3-year median level of assessment. That's what they did in the Walsh case. And, you know, for those reasons, like I said, it's not appropriate to say, well, we didn't apply mass appraisal within this subdivision or that subdivision. We used the whole subdivision. Okay, and again, I'm glad we've made that record clear on this because the method has to be the same across the taxing district, even though you could use different, or use an analysis based upon a subdivision. The fair market value drivers, the square footage, etc., can be the same for subdivision, but the method cannot be different. And for that reason, we're still on this property at the 11%, which is the 8487. Next one is 1 Stonehenge Road, Bunn family. you know, this is a good one to even talk about this. So as you can see, my clients had an appraisal on this one. You got that, sir?
Nope, not on the docket.
It's attached. It doesn't, it's not, it won't give us the same result as the last one, but I want to talk about it with you if I could.
That's what I did.
Should be at the back, sir.
Okay.
You with me, sir?
Mhm.
Okay. So on this property in 2000, last year, they were assessed at 62,541.
Mhm.
There was a proposal to take them to 107,858. We said 11%. Your proposal was about 75,000. Okay. Now your $75,000 number is only $5,000 off from the appraised value.
We did pretty good on market analysis, didn't we?
Market, I'm okay with your market analysis. But here's the question to be begged for you, which is again why, not being facetious when I say this, we'll win these appeals, is guess what? There's probably a lot of properties within Assessment District 3 that fit this fact pattern. Probably underassessed. Need to be fixed. But if you fix my client here and make them the same, what about the other thousands of properties that may be in the same situation? Because if you raise them up, then my client's not carrying the load because they're one of the very few that got raised up. So, they could have been lucky to be in the 83% of the people that they didn't do this analysis on. Then they would have only got the 11%, still being underassessed. Okay. But since they were in a subdivision that the assessor made a decision in October based on the email to the township assessor to look at, they got raised to a fair market value number, and overwhelmingly most others didn't. So even though, I'm glad this one came up, so even though their appraisal would suggest a market value number of about where you're at, give or take, they have been illegally, and I'm not suggesting malice, gentlemen, when I say illegal, I'm not doing that. They didn't make the luck of the draw and fall within the 83%. For that reason, they have a right, in our argument, to be in the 70, or the, I apologize, at the 69,420. And you know what? When the time comes and Assessment District 3 gets completely reassessed, district-wide, they're probably going to be at about 230,000. But until then, asking them to pay that additional tax when everybody else gets, again, I say a free ride, meaning that their properties didn't get looked at. That's where their argument's at.
I wouldn't change this one, we're like pennies.
So just so the record's clear on this family, it's the board's opinion that since your market value analysis on their property in Stonehenge is close to the appraisal, that if this board does not consider the argument that everybody else got just a multiplier. Is that right?
Yeah, we're not, I don't know how that, we're not attorneys, I can't speak on that. What I can do is treat everybody fairly in that subdivision, I feel like that's what we have.
That's what we've done.
I'm confident that we have done that. Now,
Okay.
whether or not that 11% covers everybody, maybe the assessment office argument is that 11% was the reassessment for everybody else, that this was an outlier. I don't know. All I know is
You
what
didn't ask her?
what I can do. No, I didn't ask her.
Can you ask her now?
Yeah,
I
I
want the
said,
record.
do you feel like that covered it? Is that why they all got 11 and this subdivision? And I think we did you not do the country club as well, parts of it? We didn't.
No,
Ma'am,
I don't have time.
Ma'am, I'm talking about. Can we make the record here for the board of review? And again, I'm not being disrespectful, that when I did an analysis that said over 8 out of 10 of the properties likely got the multiplier, do you agree with that? The 11% in Lafayette Township?
Everybody got the multiplier, yes.
Okay. And we've taken it off of the appeals property, but prior to that, everybody got it, right?
Yes.
So outside these subdivisions that we're talking about here today, and I think that Mr. Frederick just asked you about one of them, there was no review of that real estate to determine fair market value, correct?
On,
the other subdivisions outside the few we're talking about here today, there was no analysis of market value for this assessment cycle, correct?
No,
Okay. See where I'm going with that, sir?
unless the assessor did it.
Understand that. But when we did a report, have you looked at any of the reports in this?
Yeah, and on my spare time, no, I have not.
Okay,
Looked at it
okay.
extensively, no.
So properties that merely got the 11% multiplier
Right.
in Lafayette Township,
Right.
you know, your office is not aware of a fair market value analysis of those subdivisions that just got the 11%?
Oh, I have a good idea. The one you talked about in Pine Acres, that made them astronomically high.
In Pine Acres? Did
You
you
talked about the Pine Acres subdivision?
But you didn't reassess Pine Acres?
No,
correct?
because they weren't out of the realm. I mean, they were
That's what he
pretty
said.
even.
Do you feel like you're confident that the 11% covers the other subdivisions as far as market value? This
I
was
don't
the
know
only
because
outlier.
I didn't do, I mean, I applied the 11%, but I did not come up with that number. That's not my number.
And you didn't do an analysis of those subdivisions to determine
No,
market
the
value,
assessor
correct?
did that.
So how come
He
they?
No.
admitted
so
he
then-
didn't.
He come up with the 11%. That was all his number.
But he did admit that he doesn't go through the whole township on this quad year and reassess everybody, correct?
Yes.
He admitted that.
Yes.
So
And
we're
his
going with that?
recommendation was 11% to everybody, not just 11% to some.
And that's what I need the record, Mr. Frederick, to reflect, is that the rest of the Lafayette Township, they didn't even look at it.
Right. That's what it sounds like.
Yeah.
Yeah.
That's what it sounds like. That's unfortunate.
Okay. Well, not only is it unfortunate, that's the argument here I'm making for you today, is that this Board of Review has an obligation, once it knows that my clients were not treated the same way, it has to fix that. It can't just say, well, we're just looking at the subdivision, when your assessor has acknowledged to you that we didn't, and again, I know you don't have the resources, I'm kidding. We didn't reassess these properties in the assessment district. We didn't look at them, we didn't inspect them, we didn't calculate square footage. We didn't look at the sales histories of these subdivisions to say, are they under assessed? They didn't do any of that. And since you now know that they didn't do any of that, and you can say, okay, so they just got the 11%. Okay, everybody gets the 11%. So if you don't want to do that, again, we'll just have to deal with it at the next level. But you do have an obligation to understand and do that, sir. So for the property that we just did, which one was it? I'm going to make sure that that record is clear. Which one was it that had the appraisal? We just did.
Bun? I think
Was it
it
Bun?
was it Bun?
That was the last one we did.
Grafton?
No,
Grafton.
Bun was the last one we did.
So in the Bun property that we just did, I want the record to reflect that they've asked to be treated the same as all these other subdivisions to get the 11%. And this Board of Review's opinion is that we're going to apply a fair market value standard to your property. We're going to adjust you to fair market value, notwithstanding that many other properties in your own, that subdivision, as well as over 80% of all properties in Lafayette Township, fair market value was not the standard applied to their valuation. I need the record to reflect that and for this board to make it clear that that's what its decision is. Because the PTAB officer is going to want to know that. Have I accurately stated that, gentlemen?
I don't know the 80%. I don't know where that came from.
Did you read any of these appeals, sir?
Yes, sir.
Okay,
But do I have to agree with it?
I'm not asking you to agree. Do you have any reason to object? Your assessor's here. Ma'am, did you read this?
No, not all of
You
it.
didn't read it.
No.
Okay. Did your office or your township assessors, did you go and reassess every property in Lafayette Township this assessment cycle?
I don't know what he did. I know what I did.
What did you do?
I did that 4 subdivisions that are right in that area.
So you reassessed those 4
I
subdivisions?
did. And I put the detached garages that weren't on,
Why didn't you do it to the other subdivisions within Lafayette Township?
because they weren't as far out of the norm as this subdivision was. This one had a lot more. I probably had 7 detached garages that were not on the tax rolls.
Did you do an
And then that was
analysis
in
of
a-
every other
We had
subdivision?
70 tax garage and 2 subdivisions between Marksboro and Sugar Creeks.
Marksboro, Sugar Creek, and I don't know what the other 2, all of them that run together right there. There's 4 of them. There was 7 detached garages that I had to put on that were not on.
Why did you pick those 4 subdivisions out of the rest of the township? Why them?
Because they were the farthest out of market value,
Based on what analysis? Who did
based
that?
on the sales.
Who did that analysis?
I did that.
Did you do the analysis for every other subdivision in Lafayette?
I do have it, yes.
Did you do it?
Did I
Yeah.
do the thing? They didn't have as much missing things on the property records.
Well, what about the analysis, the market value analysis? Did you do a market value analysis of all the thousands of properties in Lafayette Township?
No.
Okay. So you believe, as you sit here today, that there's many other properties in Lafayette Township that are probably underassessed? that need to be-
Absolutely. And it's all the higher end houses.
Thank you. Gentlemen, come on, there was just an admission, come on, we can't let this go, you guys. And thank you for your honesty, ma'am, I'm not picking, I promise.
But the
you're
other
assessing-
subdivision weren't as far out of line as this one was.
Okay, you just had an admission that all of these other properties are underassessed, and my clients got picked out, I mean, that,
Not Pine Acres though.
no, I understand, no, I'm not talking about Pine Acres, you know.
I mean,
And the
out of the
country
sub.
club.
The country club, it does need to be looked at, but they didn't have near as much missing property on theirs as they did in certain.
But how do you know that if you didn't look at that?
I did look at them. I've got it on the spreadsheet, just like I had yours, where the red up at the top is what was missing. I've got it on theirs too.
But just so we're clear, you have acknowledged and admitted on the record that there's a lot of other properties in Lafayette Township that are subdivisions underassessed. that
Sure,
need to be
they're all
fixed.
over the county.
But again, we're just talking about Assessment District 3 right now. But you didn't have the time to do the rest of them, correct?
No, I don't have time to do 8,000 parcels.
But you have a spreadsheet of having done reassessments?
It's not in the
At the
record.
country
It's
club?
not in the
It's
record.
not reassessment, no. But it shows what's missing on the property and, yeah.
You didn't provide that
Well,
with my
this-
FOIA.
we'll wait
I
on
wasn't
FOIA,
asked for
so-
that.
Let's go to the next one. 47 Springchester.
I need a name on that.
Parcel number one.
Smith, Brian Smith and Beth Smith.
All right.
Okay, it's in Springchester. They were at 60, assessor took them to 85. We asked for the 11%. You dropped it to 72. I'm assuming it was some analysis that's not here or in the record anywhere. There were
It should be in the record somewhere.
that was not provided to me. 2, 3, there's 3 other properties in Springchester that got the 11%. And again, this subdivision, which subdivision is this one? Springchester, Marksboro. You know, Marksboro was one of the underassessed subdivisions that got the draw from the assessor, who's now admitted it to you, that they got the draw because she made some, again, arbitrary decision. I'm only going to do them because I don't have enough resources to do the rest of the subdivisions. And so they get assessed at some, again, alleged fair market value number to the detriment, to their detriment. And again, all of these other people, gentlemen, are getting a free pass. You know, I've never had an assessment review to where there's been an acknowledgement, yeah, I didn't assess any of these other people. And so, again, you can put them in the stack to assess at the 11% or not. And I mean, you've already picked one, I think it was the Bunn family, who you said you're not going to follow the constitutional argument. So if you want to make the decision that you're not going to follow that and you're going to let all these people suffer these tax increases, then we'll just memorialize them all in a list and we can move on. I've already made the record that I need to make. I don't want to waste your time. I mean, if you gentlemen need to talk about it, if you've already made your decision, I can just go through here and we can make a list of all of these folks that have made this argument. And if that's going to be your decision, I just want this record to be clear that you're making the decision that market value was applied to all of these properties with the acknowledgement that you're aware that it wasn't applied to, by the admission of your assessor, to a significant, you know, again, we can do the math, I got it in here, but acknowledges that it wasn't used assessment district-wide. I think we have that acknowledgement. I mean, what do you want to do? You want to keep going one by one? You guys want to talk about it? Is what, I mean, just say no, because I don't want to waste any more of your time. It's 2:30.
Why don't we just drop the whole total 11% on everybody's? Why are we got an 11%? Who come up with 11%?
The 11%.
Has there been 11%?
The 11% was the 3-year median level of calculation by, what's the gentleman's name?
Rex Farms.
Rex. So Rex did a 3-year median level of assessment calculation.
When did he have time to do that when he hadn't even got?
Let me finish, sir. I'm trying to make a record. I'm not trying to argue, sake of argument. I'm trying to win a case. Doing a 3-year median level of assessment calculation is appropriate in a non-reassessment cycle. When you do a reassessment and you get properties uniform, then in the non-reassessment years, you do that calculation and see what's going on. And you can make these mass adjustments on a non-reassessment year. But by the time you get back to the 4th year, if there's any changes in subdivisions or in areas of the county or the assessment district, then your complete reassessment will fix that. And then you go back to the next 3 years of doing it. Rex, and it's not uncommon, but Rex did a 3-year median level of assessment calculation for Lafayette Township in a reassessment year. He should have never done that calculation in the first place, because you fix any issues you have by reassessing all the
I know
properties.
exactly what you're saying.
Right.
I'm completely familiar with what you're saying.
Yeah.
Yeah.
And so the fact that he did this calculation, okay, then apply that number to everybody. 100% of the property owners and say, you know what, we're not reassessing properties at fair market value because I can't do it, I don't have time. Versus, again, we've made the record clear, I grabbed a few subdivisions that I thought were really bad, and I'm going to fix them. But I didn't fix the ones that were bad, I don't have time. Fix the ones that are really bad. So you fix the ones that are really bad, you ratchet them up, everybody else just gets an 11%, and so the people that you thought were really bad are going to pay a lot more in tax than the law says that they have to pay. That's the truth. And I'm not unsympathetic to your assessor that says they don't have the time. I'm okay with that. But the remedy is not to allow the assessment practices of your county, which you're overseeing, to disenfranchise a few subdivisions because of that resource limitation. That's what, again, we can get to the bottom of this pretty quick. And I know my clients are frustrated, I get it, and you know, because they're right. Treat me the same as you treat everybody else. But if you're not prepared to do that, and we can make the record clear that you're not doing that for whatever reason you feel is appropriate, then again, it's 2:30, you gentlemen got a lot of work to do today. I've only been through 6 of 22 of these, or 30 of them. I don't want to sit here and have the same conversation. You guys don't want it. You've probably heard enough, so. You want to talk about it? You want to just say we've already decided and we can come back? I mean, you guys want to confirm? What do you want to do, Mr. Frederick?
I do want to discuss it with them.
Yes,
Number
sir.
one, I do understand what you're saying.
Yes, sir.
I do respect that argument. My understanding was that by treating the neighborhood fairly,
Mm-hmm.
we were treating them fairly, but I do see your point.
Yeah, let me do that
As a
again.
taxing body, or a taxing assessment district,
Yes.
that you're still inequitable.
And I want to repeat that again because it's
No, I
important.
completely understand your argument.
Yeah, because
I've never heard it given quite that way.
I do it I've done this a long time. Neighborhoods, and it's not uncommon what you're saying. There's a lot of assessors that we've had that conversation. And when you go into a neighborhood, can I treat the Marksboro subdivision differently as the Augusta, what is it?
Augusta Lakes.
Augusta Lake subdivision. When I say treat them differently, price per square foot, how much per fixture, how much of that?
But
Absolutely.
your argument is the methodology.
The methodology has to be the same.
Sure.
Right? So,
I get
you
it.
guys want to talk for a little bit? What do you want us to leave? You want to just
Yeah,
sit
give
here?
us a few
Okay,
minutes.
thank you.
I
Yes,
just have
ma'am.
one question. Okay, you're saying just do the 11%, but what about the buildings and all that stuff? Are we taking that back off? If these guys go with the 11%?
Buildings are you talking about?
The detached garages and all the stuff that got added, which was on top of the 11%.
Well, when you take your system, what you use in DevNet, when you put in all of these calculations, square footage, and then you have drivers within that system, those systems do a calculation that's a benchmark for you to kind of use to try to set up your mass appraisal system. But ultimately, the market value that you end up with, property by property, is not just merely what spits out of that machine, right? It doesn't work that way. So if you've got all of the calculations in there correctly as far as square footage, and you've got this garage or that garage, and it click a button, and whatever that number that comes out, that's not what stays there. I mean, you ultimately have to make sure those numbers are equitable and uniform and etc. So until you guys get everything fixed in your county, how you get to the 11% result for my client, I can't speak to that. All I'm saying is that I know what it was last year. So whatever that got to last year, this year to get to the 11%, even if you're fixing, I didn't have that building, or oh, I had a second story, I got to take the second story off. You still can put that information in the system, but make sure that your numbers come out to be what they need to come out with. You
So
can't
like
just
putting
click
more
a-
depreciation on.
You can't. Most people that I've dealt with in the past, they fix it through depreciation, but you do what you want.
I have people right over there that don't like depreciation.
I don't like it either, but all I'm saying is there's a common. Go ahead, sir.
I would, if I understand that argument correctly, I'm going to say I disagree with that.
Okay.
I mean, just in fairness, that if we find a garage, not we, if they, or an addition, or in these
You have to
rural
put it on.
parts, we have to put it on.
You have to put it on.
But by making sure that whatever that change was, that addition, still comes out to an 11% increase. Is that what you're arguing?
No. Let me make sure. When you start fixing errors within your system, and you put in, like for example, you put in a garage.
Right.
What does that garage add to an estimated market value? Well, you got numbers that they give you based upon your area, your township, your subdivision, what that might add to the calculation in the system. But ultimately, what that market value is going to be is not merely just a product of that calculation. Whatever you hit the button and calculate, because you put in, where do you get your numbers from? Your square footage and your fixtures, and who do you get it from?
Marshall Swift.
You get it from Marshall Swift, yeah. Those numbers, if you read the Marshall Swift books, and I've read them all, they say these are benchmarks that you use, but ultimately your expertise has to get those numbers to where they get to go. What I'm saying is that right now, let me get to your question. Likely your properties in this system, the mass appraisal part of DevNet's probably not working correctly. It's probably not when it was set up. So whenever it's spitting out, probably doesn't reflect any of these numbers last year. Okay? They're probably adjusting to I don't know what they're adjusting. But what I'm saying now is from last year to this year, my clients have a right under the law to the 11%. How you get that to come out in your system, given that I've not looked at the tax cards, I don't know. You know what I
So
mean?
you're saying any corrections should not apply if we had them too many square feet, or this, we can't apply that either then, right?
And I'm saying you can put those into the system because eventually somebody's going to have to fix your whole system,
Yeah.
right? And so what I'm saying, when you put those calculations in now, you have to be cognizant of the fact that your numbers, whatever they were last year, if you're going to fix them correctly, that would require a full market analysis of every property. And since you're not in a position to do that, and you are stuck with 11%, you have to figure out how to get there knowing that at some point in time, we got to fix all of this stuff, right? I'm saying you can't say, well, we put in this fixtures here was wrong, this addition is here now, etc. So we click the button, and it takes them up 70%. Can't do that because that's fixing them with a methodology that you didn't apply district-wide. So it comes back in a circle.
Even if you find, say, a new garage or a new, your argument would be
That we take
the
those off.
11% has to be the cap.
No, if there's an error, because if
Right,
there's an
that's where
error,
I'm getting at.
an error can be fixed
Right,
in a year.
that's what I thought.
No, yeah, that's,
That's all I was asking.
That's the
yeah,
point.
sorry.
So
the
then those will
11%,
be
I agree with you,
20%
but yeah,
or
that's
25%
going to
or-
exceed,
It's gonna exceed
percentage-wise,
the
it's going to look
11%.
like a bigger percentage
It
of
could,
11.
it could.
Because they built another garage or they built.
The
a
case
whole-
law says
Right.
if there's an error
So
or an
we
addition.
do agree then.
Yeah,
I
yeah,
was
yeah.
disagreeing.
Sorry, I was assuming that was.
Yeah, no, I get it. I
And that's
understand what you're saying.
and that's the point I was trying to make too.
Yeah.
We find corrections that need to be made.
No, the
They
case law is
need to be
clear.
made before then we do the 11%.
Yes.
Right.
Well, then you can look at the market evaluation, right? Yeah.
Right, okay.
The
That's
case
my
law
thought.
says that absent an error in addition, yes, we're good.
All right, yeah.
Matt, quick question, just for, and you were here last time you were
Agreed.
hearing, and I think everybody agreed, and I'm gonna ask, it's a loaded question. Would you agree, as they did at the last meeting, the fix overall is for the county board to properly fund what it takes to do a countywide assessment?
And then everybody's gonna be happy.
What,
No,
nobody
That's
will,
what I'm saying.
nobody will ever be happy
When it
with
goes
that.
back up to market
think-
value,
I
everybody's
think
gonna be
that-
mad again.
Well, it's gonna be fair though.
It
But
would
the-
be fair,
but
but
the fix-
nobody's gonna like it.
It would take a countywide assessment to fix what we're seeing. Would you agree with that?
I think that from the specific things he's pointed out, yes, in Lafayette, maybe yes. But also, I think the most important thing, as Mr. DeVore, as his name said, you have to fund the infrastructure to maintain it.
Right.
That's more critical
where
than fixing it. In my opinion, if you, just like this commercial reassessment, we did it. Some would argue it wasn't fair. I thought it was done fairly well, but whatever.
Right.
But where's the infrastructure to maintain it? There is none.
And that's
It's
the
not-
argument
it's not
that we
in
as an
place.
organization want to take to the county board.
And
Because
I
it
don't.
doesn't do any good
Right.
to.
And I've talked to a
piecemeal
couple of
it.
the role
Right,
of
because if it gets redone,
Right.
somebody's gotta keep it up.
I agree.
right, and the role of
Totally
this
agree.
board should not be, the three of us should not be to have to continually fix things because we're not maintaining what we
Because
did.
their deal is to deal
Right, we're
with the
supposed to be
appeals, nothing
certifying
else.
values on appeals, and we're here looking at constitutionality issues because it's just the
Yeah,
public
because,
finance.
yeah.
And that's not fair. That's not fair to do.
That, the only thing I'm going to say is, he told you that we broke the law. The law's been broken.
I heard his
It's
argument.
gotta be fixed.
I heard his
I
argument.
don't care how you do it, but you gotta quit breaking the law, and you gotta do it right. End of story.
Cheapest way, like I said earlier, fix it at the township level. You have,
We cannot fix it. You can say, you can keep telling us that, but we can't help that. We're not part of the
you
township.
can hire someone to do the job of the township assessor, he's not doing it under the law. And you can bill the township, it's an account receivable, you can do it. It's not just a blatant cost that you don't get refunded. Once those townships are put on notice that they're gonna be billed, they'll be all over the assessor.
Well, you find me the assessors that are qualified to do that I can hire.
You weren't here earlier, you guys, but I explained to them that in the earlier hearing, we have, by motion, asked for a letter to be drafted to the township supervisor and the multi-district assessors. This was a meeting one, that that's absolutely what's gonna happen. If you're working with bad information, you're not getting the information from the field assessors, then we're gonna have to do it in this office. Now, where they're gonna find the funds to fund that up front and get paid back later, or where they're gonna find those people, I don't know. It's not an easy thing, you guys understand that, this isn't an
They're
easy thing
sitting
to
on
fix.
ARPA money right now.
But
So
that's a
you
county
gotta
board
make a
decision.
strong enough case to that
That's-
county board that this is not gonna get fixed.
You've
That's
gotta
the
understand
job.
that you surely understand all the years you've been up at those meetings that it's very difficult to understand the assessment process if you haven't been in the schooling and everything else. And I'm not certain that they're equipped to understand how this works and functions, so they rely on the
We
attorneys.
don't, we're here and we do.
Yeah.
Right, but
And
they
he's
rely
not
on
listening
attorneys.
to anything
So
we
you
tell him.
gotta make a case and make them understand and educate them. Otherwise, you're gonna have this problem every year. I don't understand. I've said this time and time again at the World Record. You don't wanna do this every year, we don't wanna do it every year. Just the cheapest way, in my opinion, unless you can tell me I'm wrong or find a better way, is to put pressure on the townships to do the job that they're supposed to do. To do it.
Let's get back to this matter.
Is there
right now.
anybody at Lakeland College that teaches courses to teach people to become assessors?
No, you have to go through the CCAO, you have to go through the
IDOR.
Yeah, you have to either go through the Department of Revenue or through,
Where are those classes available at? Are they available locally?
Springfield.
no, they're usually Springfield, Bloomingfield.
I went 2 days.
Yeah, for that, but it
I just
takes,
read the manual,
it'll take
tested
2
out.
years for somebody to get qualified.
Well, that's why I'm saying, maybe we need to make like a.
And it's
before,
expensive.
Make a plan and let's move forward. If we need 6 assessors, into the county, then we need to start getting people ready. who's gonna take these guys as places too, you know, I mean,
Right,
that's not
I've
gonna
got
be easy.
2 places to
There's
fill,
not
well,
a
I
lot
don't
going.
have it, the board does.
That's not gonna be easy.
I did this,
We do
you were
got
talking
another-
about
another 20, 30
um,
years.
my
Well, I-
pole
I
buildings
put
and
my
stuff, I
resume
just
down.
did a comparable with Rob, yours and my house.
I was
So you can look at everything,
okay.
and it tells you exactly what it's
In
assessed
the-
for and everything,
In the entrance.
and
of
what's
that
on
building,
them.
I called
Harold's
our,
like, you've got too much concrete on it. It's okay.
attorney in Warren,
It's
this
fine.
year I would be contesting.
So anyway, that'll tell you what you're at, what I'm at, and what he's at. It'll tell you everything in there.
My personal stuff.
Thank you.
And
Uh-huh.
I said, you know, in years past, it's been little things, but this year, and I always excuse myself, we do all that, but I asked him, I said, you know, do you want me to resign now? Or, I mean, we're not gonna, I don't foresee us shrinking in the future, so my term is up this year, I just won't see, he said, no, absolutely, you can do that, you can be there. So, it's my last year, but, yeah, I'm just not seeking another term.
And why would they?
We need to get on with what we need to discuss.
Yes.
Because they're sitting out there waiting on us.
So, I mean, it comes down to if you, my understanding of it, like I told him before, was that if you're treating the neighborhood fairly, then that's equity. But his argument is you're not treating the assessment district fairly by using a different methodology. And I gotta be honest with you guys, I hate to admit it, but I kinda gotta agree with you. If they're using a different methodology from A to B to C, I think you lose it at PTAB on equity.
Yep.
Uh,
I would ask an attorney.
But they gotta come up with the houses that they're getting equity to. It has to be a like house. They can't be comparing a like house, a 2-story house with a 1-story house. That won't work with PTAB. They don't do it that way. You have to bring up the
He's
exact
only arguing the
houses.
methodology.
Right, but I don't know what
So,
PTAB would do
so
with
what
that.
he's arguing, well, I don't either. What he's saying is that the methodology of flat hitting everyone with an 11%, and let's say it's this box, I don't know what it is, just Lafayette Township, whatever townships it was, you hit them with a flat, just Lafayette, you hit them with 11%. But in a small, relatively small subdivision, which we all agree, I think even he would agree, was underassessed dramatically. And I will say that your numbers were more right than wrong. Most of them were closer. However, they were right with market value, and his argument is that we didn't use market value methodology on any other parcels during the reassessment on the quad year. And I do know that outside of the quad year, you're not supposed to. This is just, I mean, this is from my research. Outside of quad year, you're stuck with a multiplier, and that's it.
No,
Unless it's a correction.
Right, unless it's a correction. Absolutely.
that's right. Every class I've taken says if you take a whole subdivision and do a whole subdivision, you can do that.
Nope.
Okay, they're talking about it.
That's just my understanding.
Well, I always thought the same, that
The
you
Kane
could take,
County guy.
I thought you could take entire subdivisions and treat them, you're treating them all the same. So that, you kept like properties and stuff in that reassessment thing. But I understand what he's saying too, that, if you're gonna reassess this home in this district, then you didn't reassess another home, because then you only can do that in quad years.
And we haven't gotten to them yet, gentlemen, I'm gonna let you talk, but we've got our Charleston properties too, which is a completely different assessment
Right.
district, so, okay, I'm gonna let you
So
know.
I mean, it really comes down to, I know that we did this fairly and equitably in that neighborhood with market value. I have no doubt, I think one of those phrases even shows that, we're within a few $100. So is it our place to argue the legality of it or let it go to PTAB? Do you want to change it back to the 11% or you want to let it just go to PTAB, let them figure it out? I'm sure that PTAB is much more well versed on whether or not this.
Whether it's legal, I have no idea.
I have no idea.
I'm not a lawyer.
I have
I'm not
his
a
word for
judge.
it.
There's no way.
I do understand his argument.
I do too,
of it
and I
being
understand the other side
I
also.
understand the other side.
So,
Right.
so and I don't make a ruling like that.
Right.
I don't know,
agree.
I'm not a lawyer.
I just don't think it's our place to do it.
I don't either.
Can't you ask the Illinois Department of Revenue? Would it be too hard to call them and ask them? And you guys
What's
are
today?
acting-
They earned in today.
Well, not today, but I'm saying if we got all these questions and no one seems to know the answers, wouldn't you seek them out? I mean, again, I can't be the smartest guy in the room. Get guidance, that's what they're there for. Call them.
The thing that bothers me, if what he says is true, and I believe he's right, the attorney, that if some people pay the 11 and some don't, we're breaking the rules, and the point with that is if that gets out to the public, we're all gonna look like fools. And it's gonna be big, and they're gonna say, well, that's not fair, if they didn't, why didn't I? You're gonna start more trouble. And I'm not after the trouble, folks, I just wanna fix. That's all we gotta do is figure out how to fix
We
it.
know the country club, let's use the country club. Outside is right, we know that it's under assessed. You feel it is, right?
Some,
Not as far out as Marksboro. I
Not-
know
not near
Marksboro
as
is
far
the most
out.
out of whack, I know that. But if we know it's under
because those
assessed,
houses are a lot older.
they are.
Some of them.
Most of them. Most of them.
But if we know they're under assessed.
In Greenbrier,
we're
most
just
of them
gonna
are
flat 11%
older,
without
1970s
deciding
houses.
what the market value was, but we're going to Marksboro and saying, okay, you're under assessed, we're gonna look at market value. I don't know. Regardless of his argument, are we being equitable? We're being equitable inside of Marksboro, but are we being equitable with the rest of the township?
And I thought our job was to be equitable to the people that came into us and
I agree,
appealed.
just look at the value in
And
front of
that's,
us.
and that's what we've done here.
Right, I
Now,
That's all we can do.
I agree.
Whether what
That's all we said.
happened,
We're not
It's-
the elected assessor
Right,
for,
right, exactly.
for Lafayette
You're
Township.
asking, it's a big ask for a appeal board.
You fix it at the township level, you're gonna have a lot less heartache.
Okay, we get that.
Everything you just said is true, but gentlemen, what you're not understanding is my clients are here appealing with a record that has laid out the rest of the assessment district. So it is relevant for you. You can't
I'm
say,
not
well,
saying it's not relevant.
Yeah.
I just don't know if we're equipped to make that decision. I'm just being frankly honest with you. I don't know that we're equipped to make that decision. We do not have that well versed in the legal backgrounds, the legalities of that form
you call
of
Jesse.
assessment.
He knows. I've already talked to Jesse. He understands. Give him a call. He represents you,
He's not a tax attorney.
Seriously, had he contacted me at all?
but he's the attorney for it.
I wish you would have called me. I'm selling chair of the board, he called me.
Yeah,
Are you?
he pops
Okay.
in every now and again, but he's not popped in or called me or.
But again, I mean, that's almost unfair to ask Jesse to make a decision on something where he's not a tax attorney. I know he's our representation,
I understand.
but he's not a tax attorney. That's kind of like asking a.
I've sat here and listened to everything that you just said. You have the analysis exactly correct. You got it.
Can you put this 11% on this year for everyone in Lafayette Township? And then turn around and out of the quad year, do an assessment on Rolling Green? After you've already put 11% on this year?
You're stuck with quad years, I do know
Yeah.
that.
Well, you're stuck, you're right, you're stuck with
Well,
laws.
the assessment's only for 1 year. The assessment's not permanent. Each year has their own assessment.
What I'm saying is, though, you're assessing them next year out of the quad. I mean, that was
Well,
supposed
they
to be
will get
this
a
year.
multiplier next year. You
But
will get a multiplier
But you can't
next
go
year.
into Augusta next year and say, we're gonna do a fair market value analysis.
But
Mr. What's his name?
the assessor feels that she can as long as she stays inside the neighborhood. Again, I'm not a legal
I
scholar, I
understand.
have no, but her argument is exactly opposite of yours, is that she has been informed.
Well, I'll just let you know that I have won that argument at PTAB 100% of the time. Because what you asked at the beginning is, with all due respect to your assessors, where she's completing the issue. You can isolate subdivisions for market analysis. You can do that. But you can't isolate a subdivision for market analysis and an assessment district and then disregard market analysis and all the others. I mean, that's where it's at. I mean, but we also keep in mind when we get to Charleston, your assessor did fair market value analysis on properties in Charleston this assessment cycle, which is not even in a quad. So, how do you explain that? You can't. So, but again, as long as the record is clear, because you've done an excellent job, sir, of laying it out And then your assessor is saying, well, I can, even in a quad year, which Lafayette Township is part of Assessment District 3, even in a quad year, I as the assessor am saying, I did market analysis in these subdivisions, and I didn't do it in the rest of them. The only thing that does for my clients is going to take me a year to get their money back at PTAB, because PTAB will issue about a 10-page opinion that says that that decision to do what your assessor says is unconstitutional and violates the uniformity provision of the Constitution, because you can apply different methodologies within an assessment. I've got the case law, I've cited it in here, so, and I know you're not lawyers,
Yeah, I was
gentlemen,
gonna say, that's a little above.
but it's, and with all due respect, Mr. Herman, but it's still a decision that this board has to, when you join to be this board of review, those principles that I'm espousing to you are guidelines that you have to make sure that your assessor follows. And if you're not sure of the answer, then again, I know Jesse's not a tax attorney, but Jesse knows that you can't do these things. So it's been argued several times, and I'm not here to politic you guys or to give my experience. I'm just telling you I've never lost that argument, because, think about it. You have subdivisions within Lafayette Township, and even though Assessment District 3 is bigger than Lafayette, all of these are in Lafayette, that have had these market value adjustments that might be right. But these other subdivisions that the assessor says, we didn't even do them. They're under assessed too, she believes they are. I'm okay with that. So they're not going to see any increases. Again, that logic is very simple. And to say, well, they're not appealing us. Yes, they are. Because they're right here, and my clients are saying, treat me the same as them. That's why what's going on in those other subdivisions is relevant for you, because you now know that those other subdivisions didn't get treated the way that my clients got treated. So, and then again, if the assessor wants to convince this board, well, I can do that, okay, again, we'll go file 21 appeals, and again, they'll have to pay the tax on whatever you proposed until the appeal is over, but then they'll get their money back. But I was hoping, what I am hoping is that the county board will fix this issue with money, because
That's you've got right there. It takes lots of money.
it takes the money, but it would be nice for your county board. Are you on the county board? You're not on the county.
No, I can't be on the county board in here.
Huh? You can't be on. I thought you could be both.
In some counties, right?
Some counties.
Right, in some counties.
It's a conflict of interest.
But either the county board's going to do it, or some group of taxpayers is going to take it into the court system and it's going to make it happen.
Yeah, I
Who
agree with that.
Who wants to do that? Right? And it's going to get forced upon you. And then there will be a judge that says, with all due respect, Mrs. Assessor, that was wrong. You can't do that. So if you want to assess Marksboro and create fair market value analysis for Marksboro and fair market value analysis for Sugar Creek that's different than Marksboro, and fair market analysis for Augusta that's different than them, not a problem at all. But you've got it, Mr. Frederick. You can't say, well, we're going to do the fair market value on Marksboro. All the rest of them, I don't have time, I ain't doing that. That is 100%. You can't do it, and that's the decision you men have to make, and it is your decision to make. And again, hope you make the right one. If not, I'll prepare 21 appeals, and we'll just have to deal with it.
Quick question.
It's up to Mr. Frederick.
Food for thought, for what it's worth. If it goes to an appeal and they win at the next level,
Mhm.
isn't there also an interest payment?
5%. Yes, 5% interest.
So since we're needing money to fix it right, the last thing I need to do is a bigger interest payment on down the road.
That's when you're getting PTAB in a year.
Huh?
How are you getting PTAB in a year?
I was hedging. It'd be more like 2 or 3.
No,
Two or three, yeah.
we just did 21s last year,
Well, we did
or
a
last
couple
week.
of 21. We also did 19s last week.
Unless we take it straight to the circuit court. I don't remember.
It's a quicker route to relief.
It is. So that's Lafayette. I mean, you're still talking about it. You want to do the Charleston ones real quick too?
Yeah, lay the Charleston ones.
I mean, with Charleston, we've got, is that box over here?
So did you guys decide on these, sticking to 11.5?
We haven't made a decision.
Well, maybe this conversation about Charleston will help ferret that out. Let's see, let's go into Charleston. How many we got in Charleston? We've got 10 properties in Charleston, I believe. Many of them are multifamily, but there's a few individuals. We can just start with PP&W Properties, 1301 Garfield.
He was part of the commercial apartment revals.
So the assessor just said part of the commercial apartment revals. I don't know how many commercial apartments you have in Charleston Township, and I'm assuming there's more than my clients. But ultimately, gentlemen, this is Charleston Township. That's not even in a quad year. It's not in a quad year.
It's kind of like doing Walmarts. We have Walmarts that are in different, but I have to do them the same year. I can't do them different years. Because then they'll use each other as comparable.
You can do them in different years, you just tell them that one's not been reassessed. I think we've already accepted this argument on the people that have brought this before the board, that the ones that were outside the quad year weren't able to be reassessed, they should have just been given a multiple. I think we've already accepted that argument with a handful of them that did come in with this argument on this second.
I don't know.
Just the ones that got reassessed.
Right,
Which
is
is my
why it's
clients.
right in front of us.
Right.
So we've accepted that argument, right?
I thought we did,
Yeah.
but
Yeah, we've
So-
accepted that argument. I personally, I know that to be true. So, again, if that's your argument, I wasn't.
That's the argument on all
I wasn't
10 of
here.
them, sir.
Yeah, no, it's not their quad year.
Okay. So we're
So
good on those
based
10?
on,
7, isn't it?
I thought I had 10, sir. I got 1 through 10?
My understanding is Albee doesn't allow that. The Albee decision, am I mistaken?
No, you're not.
Yeah. This I do know.
Okay.
So you've read that case law?
He did. I tell you what, I've been in front of a lot of boards, and I can tell you're thinking about it. I appreciate that. But yeah, so that one, you got that file?
Mhm.
What we need to do, we just go through them one at a time then?
I think your other 3 are hearing on the 14th or 15th,
Oh,
because there are 100,000 changes.
okay.
Big changes.
So those are 14th and 15th.
There were 4 of those, yes, sir.
Did you get those in the mail yet?
Yes, ma'am.
Okay.
So I have to make sure I know which ones those, do you know which ones those are, sir, of the big ones that we got next week?
I would have to look, but I can tell you what we have today.
Yes, go.
Charleston, 02 4697,
40. Yes, sir?
Jackson.
Yes, sir.
7130, Jackson.
Yep.
7132, Jackson.
Yes, sir.
17952, Boyd.
Yes, sir.
7136, Jackson.
Yes, sir.
10959, PP&W.
Yes, sir.
And 7131, Jackson
Yes, sir.
are the ones that we have in the docket today.
Okay, so we have this one here. This is the first one on my list, so we've got, and just for what it's worth, the ones that we have next week, it's the same thing.
So this is your argument for all.
All of them. It's the same thing, yeah. It's just,
Do we need to?
do you want to just go through and do your?
If that's the
We've
argument,
accepted
no,
that.
we accept it.
We understand that.
It's, all of these are the Charleston properties, sir, in the different assessment.
Yeah, we've accepted that, and other Charleston properties brought this exact same thing, the alley case up, it just wasn't their quad year.
If you could for the video.
They should be given the multiplier, however.
Yes, sir. Absolutely. That's what I proposed.
I agree.
Provide your name, just for the video record.
I'm Larry Hanner, clerk, not associated with the board. I'm not on the board of review, is what I'm saying.
You want me to just hold them one at a time, or what do
Clerk
we do?
for the assessment.
He's in charge of putting them on the docket, things like that.
Larry did an excellent job.
Assessment's the clerk for the board.
She is
I
the
am
clerk
the
for the
clerk
board,
for
I'm
the
the
board.
clerk here in the office,
Gotcha.
I'm down here.
We got 2 clerks.
The next one.
And I'm down here just right above him.
Denise, the next one's 3 Retriever Run, Jerry and Melissa Boyd. What's the one that had, Bun is the one I only want, for Lafayette, I put all the Lafayettes back for now except for Bun, the Bun house.
Charleston's quad year?
It was last year.
It was
Oh,
2021,
we missed
but
it.
she didn't get all finished with 2021, so she finished it up in 2022.
I wish you would have said she did the work in 2021, just didn't file it in 2020.
Who knows? I mean, when I listened to the video that Denise and that other gentleman did when they met with a bunch of people, I mean, they readily acknowledge, we don't have time, and we'll do pieces within each assessment district when we have time. And I'm like,
They only have from January 1st until June 15th. That's all the time they have. That's it.
The law on assessment practices in Illinois is
But if you're
grossly
doing-
behind
but,
people's ability
but
to get it
if
done.
you're, no, but
Uh-huh.
I will ask you, I'm being serious.
Okay.
If it's every 4 years supposed to be done, and then the years in between are just a multiplier, right? That's your,
Absent
right,
corrections or
right.
additions and stuff like that, yeah.
So they
And
really
then
have from
bills.
January to June, they
It
have
has to be turned
they
in.
have 2 years worth of, they could be doing this work ahead of time, certifying those values and then
No,
submitting
because
them
it
the
can't
fourth
be,
year.
it can't be done before January 1st of that year. So 2022
It can't
cannot
be.
be done before January
See,
1st
my
of
understanding is they could
2022.
do the work over 4 years.
Based on
and submit it.
21.
They wanted the
Nope.
quad.
Based on
They can't.
The county wanted the quad, this is what they get. They wanted the quad.
It still doesn't matter,
Well, they
even,
rolled off
even in
anyway.
2021, if you're doing 2021, you only have from January 1st, 2021 until June 15th when they have to have it turned into me. That's all they have for 8,000 parcels.
Yeah, but districts are townships.
There was more than one township.
One person can't do 8,000 in that length of time.
Is that something that's in the state statute
But
that
if you can't do the
Sure.
work over 4 years, then
Yeah,
yeah.
they have to have it turned in to me by
Then-
June
then you don't have the
15th.
time. I mean, you'd have to have a fleet of people, so you are limited to, which is fine.
Now, do I take things after that? Yes, I do. But statute, according to statute, they have to have it turned in to me by June 15th.
And they go do this quad, and then the same team goes and does this quad, and this quad.
That's what the law supposed.
And if they
That's
have it
what-
done,
that's
then
what-
you have
sure.
4 more years, then you gotta have it done.
Gotta have the funding, right?
Just like everything from the state, put it out there, but
Now,
don't.
funding's there.
Yeah, it's
That's a tough one.
It's a tough issue. All right, you get the next one, ma'am? I'm sorry. The next, we did Boyd. Jerry Melissa Boyd.
That's the one we've got there.
After that, Denise is 1558 4th Street, Jackson family.
So these
All
are
of them?
all outside of the,
These are all Charleston's.
so
You
you
have
to,
You have this sheet if you.
I got a lot of sheets.
Here's Jackson, here's 4 Jackson families.
Yeah, it looks like there's 5, 1558, 4th, 15.
Oh, yep. Sorry, I had one in my
Got
lap.
5.
Yep.
So what, my vote would be to do what we've accepted on the
we
others.
did
It's outside
it,
the
yeah.
quad year, give them the multiplier. There's no reason to go over all these, they're out of quad.
They're all the same.
So I'm gonna initial them,
There's 7 of them.
and then I'll put a note on top of them. You just can't, they're gonna have to get you more help.
You know what most counties do?
Well, they do.
They just do the multiplier all the time.
I know.
But is that fair to these people that have $30,000
That's what they do.
houses?
Yeah, that's what
It's
they do.
not fair.
It's not fair. I agree with you. But if you're gonna fix it, you gotta fix it all or none.
No, I didn't know that.
Most counties just do the multiplier. And they'll do an addition or an error, and new construction.
Most counties have county zoning though where there's permitting. We don't. That's the problem.
Hard to catch some of that
Outside
stuff.
the city of Manatee,
No, we
or
don't
the
have
city of
any.
Charleston, there's no permitting. We don't know what's been.
You don't know what's getting
Unless you
done.
just drive
Nope.
by it in the woods and see it.
You don't have permitting in
Nope.
this county?
No.
Only
you will-
in Mattoon
you will
and Charleston.
literally find houses that have been.
In this
15
county,
years.
How many people live in
I know.
Coles County?
It just dropped under 50.
Nobody comes in and says, hey, I'm
Do you have zoning?
We do not have zoning.
Do you have a county zoning
We
code?
do not.
Holy shoot!
Yeah, it's not okay.
But it's not 50,000 people.
Right,
Even,
that's the
even in
problem. It's a
Sugar,
big county, not
even in
a
Sugar Creek and Marksboro, they don't have to get building permits. They have no zoning.
It's not within a
Nope.
mile and a half of the city, so
Nope.
they don't have to
Nope.
follow the city's subdivision ordinance?
Nope. That's the reason there were so many things we didn't have.
I understand, I get it.
Okay, easy enough on that one.
Charleston's done?
Yep, done.
Okay, so we're back to you gentlemen again, you just have to let us know, you
I see both sides.
you
of the
clearly
argument.
where
It's
you're
not-
at.
I gotta be honest with you, I don't know that we're equipped to make that decision. I do understand your argument.
Well, then you just have to make the decision that you're going to let the fair market analysis of these
Right.
properties run.
To
and
go
not
on the
exactly
PCAP,
appeal.
right.
Yep.
No, we're not, you know, I got the office telling me they can do it, I got him telling me they can't. I don't have a judge in front of me telling me they can't, so.
Well,
I ain't the only way to get it done, so
These are different.
I don't think it'll get
A
done.
PCAP decision in this case, if he's successful, in saying what he's saying, has the potential ramifications to actually fix the whole county. Right? I mean, if you get a judge.
Not
to say-
legally.
no,
The PTAB ruling will only apply
Well,
to
it
these.
should open the eyes, I know that, but it
It
should
won't.
open the eyes of the county board and say, okay, we need to do something, right?
nope, won't happen.
In my humble opinion.
I hate to hear that.
It would take, yeah.
Yeah.
But at least we can, the record will acknowledge that,
And my
fair
thing is,
market
this
value-
was the quad year on this.
was it quad year
It
in
was the
here?
quad year, we used
And-
fair market value, yes, we did.
Fair market value on my clients,
Yes.
but we acknowledge that
We
fair
used on
market.
everybody in Marksboro,
Yeah.
just Marksboro. I mean, I'll acknowledge it. We took Marksboro as a, oh, I'm sorry. It is a unique neighborhood, I mean, as far as, and I do see your argument, but it is its own, and it was the farthest out of whack by a lot. And I think you can admit that.
But it was, I knew it was out of whack, but we're going to acknowledge that that analysis that was done in Marksboro wasn't done
I agree with that.
everywhere else. Okay.
Right, because it wasn't from the board did that analysis, not we just did that.
Right.
One suggestion that may help everybody, give Jesse a call, ask him to come down to hear that analysis and get input. That might solve this real quick. Because this isn't a really deep legal question. It's not my opinion.
It's not really, I mean, can you treat or can you look at that subdivision during its quad year and change
So
it
how
by
are you gonna
itself
do
or not?
that if we reval the whole county?
I mean,
It's not gonna be all the quad year.
You gotta do it by quad year.
Well, then you drop the quad year thing and say we're gonna do it for 1 year. I mean, county board made that decision.
Right.
They can make another.
No, the state has to make the decision and pass it to the county board.
But then you
It
just
has to
do
be
a
okayed by the state.
district-wide reassessment 1 year every 4 years.
Right.
Do it that way. Maybe you can bite that off easier than the whole county at once. What's next year? I forget, District 4 or 5? What's that next?
That's another way. Yeah.
Yeah.
2023 or 2024?
24.
24 is Matt Toon.
Matt too.
So
There you
go.
Start there.
That's what he started with.
You can answer your question.
But see, you guys didn't think that was fair when they did it that way. The county reassessment doing it by the quads.
No, no, our argument was never the quad, I'll be very specific. We never argued that we didn't agree with breaking into quads. What we said was, since the values hadn't been done in 16 years, the fact that they reassessed quad 1, which is Mattoon, and then reassessed everyone after that, had Mattoon paying a disproportionately unequal
Right.
amount.
So
of
how are you gonna do that?
But it's-
So
but it's
sharing
legal.
school districts
It
with
is
other
legal.
ones.
Yeah.
What you should
He
have
said
done is
it's legal.
broke into quads, reassessed the whole county, and then hit everybody after that.
That would have been a
That's-
plausible possibility.
You could have done it that way, but you could do it the other way they did it.
Legally, you could do
No.
it the other way.
Yes,
The
you
other,
could.
the
He
rule
just
book-
said it's legally they
The rule book
could.
says, the rule book states you can't have inequity in the assessment. So if Lafayette Township was sharing with Mattoon and Mattoon got done, and the people in Mattoon are disproportionately paying for the same service but paying a higher percentage, it's against Illinois rules. Page
See?
17 of the rule book.
There's no winning.
We don't have that fact pattern in front of us.
We do, we got it, you got it. I got it.
All right, so
All right.
I would make a motion, I think we're just gonna look at this. We've treated Marksboro fairly with a market value analysis, as you said. Was that analysis used in every, no, it was not used in every subdivision. It was their quad year, however. And I know we've got it, we've fixed it. I mean, a lot of them came back down. We've fixed them considerably from where they were. I think the initial reassessment was too high, but that was based on erroneous info. One of the residents said, I mean, they had all kinds of stuff wrong.
But that was been wrong since day one when it was.
No one's looking at it.
It's worth interesting at pointing out too, is like, I'm just looking at, let me go find that here. Let me find that. I'm looking at the Larson family, Chad and Heidi. They were 96,325. The assessor took them up almost double to $189,000. 96% increase. We said, give us the 11%. You dropped them based on your opinion to 129. So you knocked off, or I'm sorry, 124. So you knocked off almost $200,000 of value yourself. Okay. And again, being respectful to you. You found that much flaw in the analysis that was done.
Yeah.
But yet, we're going to sit here now and accept the proposition of your assessor that I can cherry pick in a quad year subdivisions. I mean, do you feel comfortable making that decision now, or do you want to give it call somebody and give it a day or two? It's your decision, whatever. I mean, I'll file 21 appeals if I have to, but if you guys say, look, we're going to table this, give us a day or two to run your decision, it's up to you. But I think if you make a call or two, start with Jesse, call somebody else, I think they'll answer the question for you.
We've got till the 15th. We've got to the 15th
No.
to certify these values, so
I don't
Let's
have,
do it.
I don't have
Let's
money
do it. Talk
allotted
about
for
it
a lawyer.
next week when I come back on that.
you got
I
more.
guess you still want me to come back on the $100,000, right?
You got 3 more, yeah, that's.
It's the Charleston.
That's the 15th, that'll be the 15th.
Yeah, you want to do that? Talk to a few people?
I'm fine with that, they're fine with that.
I
Yeah,
don't
Jesse.
want to make a decision right
All
now.
right, good. All right, that's what we'll do.
Okay, let's do that.
Table it for, we'll talk to Jesse.
Pleasure, sir.
Thank you.
Thank you, sir.
Thank you.
Yes, sir. Thank you, sir. Larry. That's a good one.
Thank you. I think it's
Thank you, guys.
Was yelling at worse this morning.
Did you get some fire you went
Oh, you get some every once in a while. You get upset.
That's why you get paid the $10.
Yeah,
Try to
Not
cover
near
the cost
enough.
For hours.